Hi, everybody. Thanks so much for coming today. I'm going to be talking to you about the Inheritance Act. We've been doing a number of sessions on the Inheritance Act, whether it be particular claimants who can bring claims or the purpose behind the Act for the last few months. And we've been really diving deep into the nature of the Act and what it means for our clients. But today, what I wanted to do was talk about how we actually move those cases forward. A lot of the time when we're giving our training, we tend to focus on settlement, early settlement, and how we can achieve that for our clients. And that's fantastic. And where we can do that, we like to make sure that we focus on it. However, there are some occasions where we have to go to court and we have to be very mindful of that possibility from the outset. So I'm Eleanor Stenson, I'm a partner at IDR Law, and today I'm going to be talking to you about litigating cases brought under the Inheritance Act. So in our previous training, we've talked to you about what the purpose of the Act is, and ultimately it boils down to this. A person is entitled to leave their estate to whoever they wish to leave it to. But sometimes people make strange decisions. And in order to protect people who are in need as a result of somebody's decision to leave them out of their estate, the law protects them by imposing this act, which means that they are able to then make a claim through the courts for provision from that person's estate. Effectively, the court is making a moral judgment here, and if successful, the claim has the outcome of changing the way in which the person's estate is administered. So, practically speaking, that means that if somebody has been left out of an estate and they can't reach an informal or at least without lawyers agreement with the estate, then they have to assert their claim. We've talked in previous training about the different types of eligible claimants, so I'm not going to go into that just now. Safe to say that when we are instructed by a claimant, we assess their claim and we prepare what is called a letter of claim for them. We engage then in correspondence with the estate and with other beneficiaries, and this is called pre-action correspondence. This pre-action correspondence is really important. It's the point at which you're asserting your claim, you're providing evidence, and you are setting out exactly what it is that you're trying to obtain from the estate. It can take a long time, and especially if there are negotiations ongoing at the same time, that can be really time consuming. It can be very frustrating. You can be waiting sometimes months to hear from the estate or other beneficiaries after you've sent your letter of claim. It can also lead to having to issue your claim at court, which is an expensive and stressful prospect. It is always hoped that pre-action correspondence would result in an early settlement, as I said, but the purpose of today is to look at what happens if that isn't successful. And I think it's worth bearing in mind that claims brought under the Inheritance Act are quite different from other claims, particularly in the contentious probate sector. So, what does set a claim under the Act apart from other types of claims? Well, first of all, there can often be a very tight timescale in which to fit in those pre-action discussions or negotiations. The Act provides that claims under this, that claimants must issue their claim quickly if a grant has already been obtained. That's because the courts don't want the estate administration to be held up by lengthy litigation. So the 6-month time limit for bringing a claim applies once a grant has been obtained. That allows the executors or the personal representatives to be put on notice quickly and to try to deal with what needs to be dealt with within that time. Or alternatively, it pushes the claimant to make their claim and to pursue it quickly so that then it can be, in an ideal world, resolved more quickly and the estate administration finalised. When claimants bring their claim, they have to justify the reasons for it. So what they're doing is demonstrating to the court that they are not only an eligible claimant, but that also they should be provided for from the deceased estate. There are some occasions where an eligible claimant may be eligible to bring their claim, but actually the fact that they haven't been provided for, or the fact that they've been provided for only up to a certain extent in the will or under intestacy, is reasonable. And the court may find that even if somebody is eligible to bring a claim, that they have been provided for and that they are entitled to nothing else. But to get to that point, you need to provide significant amounts of historical and personal financial evidence. Essentially, you are proving the nature of your relationship with the deceased. You are also proving how that relationship worked financially, whether there was financial maintenance, how you lived your lives together if you were cohabitees, and really going into quite intimate detail about how your life was lived with the deceased. It can very often feel that those personal finances and that personal information is under a lot of scrutiny. Similarly, you will find that the relationship, the nature of the relationship, and the evidence that is provided is under scrutiny. And that is because ultimately a claim under the Act is often met with competing claims. So there are often competing beneficiaries waiting to have decided for them by the court what they are entitled to. So this creates a very hostile mix, and where you are corresponding and trying to set out your claim in the most assertive way possible, and in a way as to try to reach an early settlement, you can find that you are up against quite hostile and quite aggressive tactics from other parties. So I mentioned earlier the tight timescales for negotiation. This is where we have the 6-month time limit. Ultimately, if there is a grant, the Act is clear. You must issue your claim within 6 months of the grant. You may not have known that there was a grant obtained in the estate until 5 months after the fact. You may have been aware the day after, but either way, 6 months, 1 month, 2 months, it is not a lot of time to negotiate, to set out your claim and then negotiate on that claim. So you have some options. If your client is faced with this prospect and it just seems impossible to be able to set out a claim in a letter of claim and to actually have effective negotiations, then you can issue your claim. Of course, you can protect your client, protect the claimant by lodging the claim at court. That stops the clock. But you are, of course, incurring immediate and significant costs. And arguably, many clients choose to incur those costs in the preparation of a letter of claim rather than a claim that is to be lodged at court, even though they're both pretty similar in the level of detail that they contain. You can also, assess the risk and balance the risk, and then decide if you want to take the risk of being able to settle the claim before the time limit expires. That will require the letter of claim to be drafted, and it will require quick action on the part of the parties. But you may find that even in those circumstances, it is necessary to actually issue the claim at court to stop the clock, and then to look to reach an agreement with the other parties, either for a stay of proceedings, which the court can order to give parties breathing space, or for there to be some standstill agreement put in place. A standstill agreement, we could have an hour's worth of training on that alone, and particularly given the fact that the court has treated parties' standstill agreements quite differently over the last few years. In essence, a standstill agreement is an agreement to put a pause on proceedings and limitation periods, such as this 6 months. It is something that the parties enter into without reference to the court, so it's a contract between the parties. The safer option is to issue proceedings and seek an immediate stay of proceedings, because that is something the court has to order. And if the court orders it, and particularly that it would be unlikely for there to be any resistance if all parties agreed to it. If the court does order the stay, then you are safe in the knowledge that the court is completely in agreement with how things need to proceed. If a client approaches us who has said to us, well, a grant was obtained, but a grant was obtained a number of years ago, or even 8 months ago, it is possible to apply for permission to bring a claim out of time. The courts have been favourable towards applicants who make those sorts of applications in absolute good faith. So somebody who comes to the court to say, I had no idea, I tried my best, I wasn't aware of this grant being obtained. And it was only once I contacted IDR Law that they told me that there was a grant. The chances of having that application approved and being able to issue your claim out of time are quite high. If, however, you've been aware of this grant for ages, it's quite clear that you've been taking advice and that you just haven't done anything, as an applicant in those circumstances, the court may decide that actually you've had your chance and it is now not something that they are willing to allow to proceed through the court. So either way, we've got to be mindful of it. We've always got to be careful of this 6 month time limit, and we've always got to consider whether or not we have suitable options, whether they are the right options for the client, and how we can best manage things for them in a way that doesn't create disproportionate costs, but actually protects their position. So if there isn't the time limit in place, that means that there's no grant. So you could be forgiven for thinking, well, that's great because you've got loads of time to negotiate. You've got plenty of time to assert your position and get things settled before a court case is needed. But often in these circumstances, if there isn't a grant, it may be because the people in charge of dealing with the estate have not been identified. They haven't asserted themselves. Perhaps there's an intestacy and the position is unclear as to who should be in charge of the estate. If there was no next of kin, no biological relatives, that there does need to be some further consideration there. And what that could mean is that you are then forced as a claimant to try to force the hand of the people who should be in charge of the estate, simply to have put on record by a grant that they are in charge of the estate and they are the ones who should be dealing with the claim in the first instance. This can be a disappointing prospect for clients because arguably it adds to their costs. There is some uncertainty there, but for us to be able to pursue things through the court, there needs to be parties identified who can respond to the claim. And it's as simple as that. The court will want to know that whoever should be responding to the claim and whoever should be dealing with the claim is notified and able to engage with it. Similarly, there is always a risk of dissipation of estate assets. So if you have a situation where there isn't a grant, but there is somebody who is dealing with things, you can find that the extent of the estate, i.e. the estate assets, are called into question later on because there's been some early dissipation or sale of those assets, and the proceeds can't be traced. It is just simply better practically to know who is dealing with the estate so they can be on notice of it and be there to respond to the client's claim, whether that is issued at court or whether that's in response to a letter of claim. So I mentioned earlier the level of financial disclosure which is required in these cases, and the risk of that financial disclosure being scrutinised very heavily. What I wanted to show you was a document which we prepare for our clients, which asks them to provide probably more financial information than you might have to provide if you're applying for a mortgage or something. It's exceptionally detailed, and it's something, but it's something which is required and something which I think a lot of potential claimants don't quite realise. So just turning onto this now, you can see here we've got a document which asks for details of all the assets that you have, your income, what other income you might have, rental, accommodation, etc., and then all your liabilities. And these tend to be the most contentious because they go into things like clothing and entertainment and things which are very, very easily criticised by your opponent. Hairdressing costs, beautician's costs, things which are part of normal life and ought to be included in any claim under the Act, can often feel frivolous or can feel to some extent something that is capable of being criticised. This is quite a difficult prospect for clients. It can feel really violating. It can feel very personal, and it can feel like you are exposing your personal life and your personal finances in a very vulnerable way. As I say, your opponent can criticise spending and can criticise, that the application you are making for financial provision from the estate as being not reasonable, because actually it's to fund things which they deem to be unreasonable as part of lifestyle expenses. For example, if you had a single person, a cohabitee, who was claiming for provision of a deceased partner's estate, and they were claiming for a 6-bedroom property with a swimming pool and acreage to go with it, then the opponent would likely say that seems excessive and it seems unreasonable. Alongside that, if there is excessive spending or spending which is deemed to be excessive by your opponent, then that can be heavily criticised, and you can find that actually your client's expectations need to be altered and managed quite quickly and quite carefully. So for us, the obtaining of that information, the financial disclosure, helps us to understand what the expectations are, helps us to understand what the reality was of the life that they lived with the deceased, or that their current need for financial provision. It helps us to formulate their arguments from the strongest possible position. We do have to, on occasion, talk to clients about how we how we demonstrate that spending, how we put that forward, and sometimes it just needs to be altered slightly to make it clear why that spending actually is necessary and reasonable in the circumstances. So, taking a step back then, how might the court treat certain claimants differently from one another? We have a number of eligible claimants under the Act, which are set out in this image here. Spouses and civil partners, ex-spouses and civil partners, cohabitees, biological children, individuals who were treated as a child, and then also individuals who were maintained by the deceased. For the most part, they are all treated pretty similarly. And I have just listed out exactly what the court looks at when it considers a claim. And these are common to all cases. So what the court looks at initially is the finances and resources of the claimants. Again, we're going back to this financial disclosure, and we're seeing how important that is to the court because it needs to understand the full picture. It also needs to understand how that might change. So there may be illness or there may be upcoming retirement, which means that the financial position is not going to remain as it currently is set out. Separately, it's important for the court to understand what obligations and responsibilities the deceased had towards everybody really, but particularly when you are a claimant, what responsibilities did the deceased have to you? What obligations did they have to you? Were they paying, were you a cohabitee and they were paying all the bills? You didn't work, they paid for everything. They kept a roof over your head, made sure that there was always food in the fridge, and that you went on holiday each year. That those kind of responsibilities and obligations are the key things that the court would want to look at here. Separately, it needs to know how big the estate is. It seems obvious, but actually we see a lot of times clients who come to us to talk to us about their provision from a relatively modest estate. And there may be numerous beneficiaries, and we have to say that, although it feels that you might have got more because there are other competing beneficiaries and they are all eligible claimants, there is every chance actually that to litigate, to go to court on these issues will be completely disproportionate in costs, and you may find that you spend more than you actually receive. So the size of the estate is really, really important. The nature of the estate, all that means is how it's made up. So is it made up of cash in loads of bank accounts? Is it made up of a number of properties which would need to be sold in order to pay out to claimants? It's worth knowing that and knowing how any result would be put into practice, what the methodology would be for the court actually altering the distribution of the estate from the outset, because ultimately you would like that to be part of an agreement at an early stage rather than having to wait for the court to deal with it. So if there are a number of properties, you might want to consider how your client's claim might be settled by a sale of one of those properties, or whether actually part of the claim is that the property would be transferred into a client's name. So it's helpful to think those things through at an early point. Likewise, the court needs to know whether there are any special considerations, so any disabilities of any applicant or beneficiary, which might mean something as simple as they're unable to work, or they're only able to work limited hours. It just helps the court to understand what their personal circumstances are, their earning power, and actually what their needs might be over and above that. Finally, anything else, including the conduct of any of the parties. This is just to make sure that the court insists upon knowing the full picture here. Have we got people who have hidden documents, hidden deeds to properties, or similar types of things? which could make the court think twice about their motivation in either making or defending a claim. So separately, spouses and civil partners are looked at differently. So those factors that I just went through are common to all cases, including spouses, but any spousal claim is considered in a slightly different way in terms of how the court assesses what reasonable provision would be. So the spouse, the civil partner, treated exactly the same. They must have been legally married. They have their own special definition of reasonableness. The court effectively undertakes a hypothetical divorce when it decides what reasonable provision ought to be. So it looks at the marital assets. It looks at how they ought to have been distributed if the deceased and the claimant had been divorced rather than the deceased having died. As part of this, as you'd imagine, they look at the age of the parties and the duration of the marriage, as well as the individual's contribution to the marriage. So just because somebody didn't work and stayed at home and looked after the children, that doesn't mean to say they did not contribute to that marriage. In looking at this, it's important from the court's perspective to have details of all of the marital assets. What I wanted to touch on here was a case which I dealt with a number of years ago, where there was a very distinctive and unusual set of circumstances in the way that the husband and wife lived, which was to say that they lived completely separately from each other. They both had their own houses, they had their own finances, and really the only thing that they spent any money on jointly was going on holiday each year. But even in those circumstances, the court still treated their own assets as being part of the marital pot. So it was looking at it in such a way as to say, this marriage, even though it was separate in some respects, if you look at it overall, each party brought their own assets to the marriage, even though they kept those assets in their own name and they were effectively completely separate. So I think it's worth bearing in mind, particularly for a spousal claim, that just because there might be some unusual circumstances there doesn't mean that the claim itself is in any way limited. The court has the discretion to look at this as a whole, look at all the marital assets and make a decision from there. So I mentioned that there's a difference between how the court looks at reasonable provision. Its starting point for any claim is to say, was there reasonable provision for the claimant? And I mentioned earlier about a case where perhaps the estate is very small, and even though there might be some desire for a claimant to have received more, it may be that actually their provision is reasonable, taking into account all the circumstances of the case. But if the answer to that question is no, the claimant has not received reasonable provision, then the next question is, well, what does reasonable provision look like? So for spouses, the reasonable provision is provision which would be reasonable in all the circumstances for a husband or wife to receive, whether or not that provision is required for their maintenance. This goes to the case I just talked about. So just because somebody's got their own assets and things in their own name doesn't mean that they are not entitled to a share of their spouse's estate, because it was all part of the marital pot, and it was all designed to be shared, even though it was held separately. Then we look at any other claimant, what is reasonable provision for them. So this includes cohabitees, who often mistakenly believe themselves to be common law husband or wife, which of course doesn't exist. They have to prove their claim purely on the basis of maintenance and need. Their provisioners would be reasonable in all the circumstances for the applicant to receive for his maintenance. So that doesn't give them any special treatment, and particularly for cohabitees, that can be a very difficult situation to come to terms with. So what's the likely outcome? What does the court do from here? The court's made an assessment. It's decided that there wasn't reasonable provision, and it's decided that there needs to be some reasonable provision, and it's made an order for a certain figure or for a certain outcome. So how does the court deal with that? Well, it's pretty straightforward, actually. The court, despite me saying that the court makes a moral judgment, it doesn't actually say, that anybody is right or wrong at the end of this. It just makes the order that there wasn't sufficient provision for the claimant, and that claimant now ought to receive something from the estate or something additional from the estate to satisfy their claim. This can be a lump sum, so cash payment. It can be periodical payments, or even, in certain circumstances, it's possible to set up a trust, particularly for minor claimants, where they receive a certain amount of money settled on trust, which they're then entitled to either at reaching a certain age, or they are entitled to discretionary payments as and when. Alternatively, you can have a transfer of a property. So the court could say, well, for example, a cohabitee was being provided for by the deceased. The deceased paid the mortgage, put the food in the fridge, kept the roof over their heads. They are entitled to accommodation, and they are entitled to receive that accommodation from the estate, and particularly if there are one or two properties, or a property and cash, which could be used to satisfy any other claimant's claims or any other beneficiaries' entitlements, then it is possible for the court to say that property can be transferred to the claimant. If we can't wait that long and we've got to deal with, we've got an urgent financial need, either for the payment of legal fees or genuinely because somebody is to be destitute if they can't receive money from the estate urgently, it is possible to say to the court that we need an urgent order for an award to be paid to them. This gives them immediate financial assistance and allows for a bit of breathing space, because again, once you are in proceedings, it can take a long time to reach that final point. Even if you are negotiating behind the scenes and there is prospect of reaching a settlement, you may still need some financial support from the estate. Best practice is to raise that issue with the estate, the executors or the personal representatives at the earliest possible stage. They may just agree to it rather than you having to make an application. So it's sensible to at least ask, and certainly it bolsters any application you have to make if you raise the issue at the earliest stage, because it supports the urgency and that need for assistance to be provided immediately. I've put here as well that when the court makes orders for provision from the estate, it can only provide from the net estate. So that means after payment of tax, after payment of funeral expenses, and other liabilities. But then I've cryptically put, or can it? Because the court does have the power to claw back property that falls outside of the estate. So taking to one side the issue of funeral liabilities and things like that, which will always need to be paid from the estate, if there are circumstances which have led to significant bits of property or assets not falling within that net estate, then the court can look into it and the court can make various orders to make sure that actually that is taken into account in the pot that's available for distribution. This tends to be in circumstances where there are multiple claims which need to be satisfied, but also if somebody deliberately tries to exclude certain assets and property from their estate simply for the purpose of defeating any applications for provision that might come after they've died. So, for example, looking at jointly owned property, if the deceased was in a joint tenancy with a co-owner of a property, the law says that on the deceased's death, the surviving joint tenant receives that property. Absolutely. So they receive it 100%. And that falls outside the estate. So it wouldn't be caught within this net estate that's available for distribution. However, if at the point of at death, there was a joint tenancy which actually was capable of being severed and therefore turned into tenants in common, which creates two separate beneficial interests in the property, then the court does have the power to retrospectively sever that joint tenancy and say, no, it isn't right that the surviving co-owner receives the 50% share of the property. And actually that 50% share needs to be brought into the net estate, as it would have been had there been a severance of that joint tenancy and the property owned as tenants in common. It's unusual, but it can happen. Likewise, if there are transfers of property made suspiciously close to the point at which the will is made, or perhaps suspiciously close to death, the court does have the power to hear applications about how those transfers may be deliberate and intending to defeat a claim for provision, because sometimes people do make strange decisions, and sometimes people, as part of those strange decisions, actually take steps to remove assets from their own estate before they die, so as to keep it separate and to avoid somebody who may have a claim being able to claim for any more than perhaps they might have wanted to. This is something that the court treats incredibly seriously, because it has there's the sort of mirror laws in insolvency where if a person is sort of soon to be made bankrupt, and instead of keeping their assets in their own name, they transfer things out so as to make sure that their creditors can't sell their property or sell their boat or something to pay their debts. It has that same effect. The court sees it as trying to create a situation where people who have a legitimate claim on your assets are not allowed to pursue it. There are also some instances where people enter into contracts to leave property by a will. Just referring to a real life example that I had, where there was two friends who one had lent the other friend quite a significant amount of money, and the friend said, the friend who received it said, look, I know this sounds crazy, but I just won't ever be able to pay you back in the next few years, and I hope that we can come to some sort of agreement. They came to an agreement, but the agreement ultimately was that if the friend died, then he would make sure that his estate covered the costs of covered the loan, the repayment of the loan back to his friend. And in really sad circumstances, that will was drawn up and ended up being something which our client wanted to rely on to say, but he promised to pay it back. Obviously, he's now deceased, but he followed through with his promise to leave me something from his estate to cover it. So the court does have the power to void any contracts to leave property by a will. And in doing so, it looks at whether or not they are designed to defeat claims. In that circumstance, it wasn't. There was no intention there to defeat any claims by anybody else. It was simply for the purpose of recording repayment of a debt, and sadly it needed to be used, and everybody had hoped that it wouldn't be. But the court does have that power to look at the steps that the deceased has taken and whether or not those steps can create a situation where a claimant may be deprived of claiming against certain assets. The final thing I wanted to touch on today was about how a client's expectations might be managed as an overarching point. Most of our audience for these training sessions are non-contentious practitioners, and often when they are signposting clients to come to us to talk about potential claims, it's helpful to know what to say to them and helpful to know how to provide them with context on what they're letting themselves in for, because often it isn't appropriate to provide any sort of detailed advice. That's what we're here for. But in signposting them and giving them an overview of what sort of claim they might have or what sort of discussions they might need to have with us, I wanted to put this slide in because I think it's important to recognise with clients being referred over to us that any claims under this Act, whether they're settled out of court or a contested trial, are emotional and very stressful. They can take a long time. They can be very expensive, and they can feel quite upsetting because the clients have to justify relationships. They have to justify finances. It's very personal, and it can feel like intimate details are having to be disclosed, which can make the claimants feel particularly vulnerable. However, we do not see them going to trial regularly. We see them settling. And that is a point of comfort that I wanted to offer to clients being referred over to us, that overwhelmingly we see these claims settle, and settle early on, because everybody recognises that the cost of litigation ought to be avoided, and that ultimately the estate can't be administered until the claim is sorted. So overwhelmingly, they do settle, and they settle early. However, always got to keep mindful of how you can settle the claim, even if it's not done early. So if you do have to issue because you've got a short time scale to do so, keep ADR, alternative dispute resolution, in mind. Mediation, negotiations, they're all available right up to the point where you walk in the courtroom for the trial. You can settle at any point. And as a last point, it's always worth managing people's expectations as to what might be received. It's what is needed rather than what should be awarded. It can feel very upsetting to approach these sorts of claims and think, for example, as a cohabitee, that you should be entitled to 50% of the deceased's assets because you were effectively common law husband and wife. That isn't necessarily the outcome. And quite often, where we're looking at a client's needs versus what they want, that can fall short, and it can feel almost a criticism of the relationship. It can feel like even more frustrating and upsetting than the whole situation anyway, when you are being told that actually the likelihood of you receiving what you think you should receive is quite limited. That means that we have to have open conversations, frank discussions at the earliest possible stage, but also sensitivity and sympathy to people's situations, which are very vulnerable and simply looking for support and guidance. So we look to be honest and explain everything as carefully as we can, talk through what our expectations would be for somebody, and try to manage their own expectations accordingly so that everybody's going forward on the same page. And even with the amount of financial and personal disclosure, that everybody's doing so sort of fully in the knowledge that they're putting their best foot forward. So that concludes my talk today. Thank you so much for listening. Because of various exciting commitments at the moment, this has been recorded in advance rather than being a live webinar. So if you do have any questions through, please do send them through to us. We're always willing to talk about things that crop up in our training. Likewise, if there is anything that you would like to see in future training sessions, please do let us know. But otherwise, thank you so much for listening.